Say that we have differences, but those are healthy differences. Motantor, monantor nohoy. Uh, and two brains will not think alike. We have a lot of ways to look at, but nevertheless, thank you very much for this important gathering today. Without wasting much time, well, I do not want to go into these issues of post-coloniality, state and citizenship. Particularly, I would like to focus on the bill, which, as my dear friend Akhil has said, is hogging the limelight today. And in fact, the civil society today is burning, in fact, in Assam because of this issue. So, I expect our distinguished panelists to address those issues, but let me come directly to the Citizenship Amendment Bill 2016. Well, I have 7 points to make. Well, my first issue is that in this issue proposed Citizenship Amendment Bill, which has already been passed by Lok Sabha, it has two dimensions. One is the retrospective dimension and one is prospective dimension. Well, what is this retrospective dimension? That retrospective dimension is to be understood from the notification by the government order on Passport Entry into India Act 1920, an application of the provision of Foreigners Act 1946. There we see a kind of retrospective dimension of the citizenship issue. The prospective dimension is to be deduced from the CAB, that is Citizenship Amendment Bill 2016, that is essentially silent on the cut-off date of removing the tag called the illegal migrant. So we must understand as we go along, these two aspects need to be taken care of, the retrospective and the prospective dimension of granting, I would not call citizenship, but removing the tag called illegal migrant, because illegal migrant doesn't, when you remove it, doesn't necessarily mean citizenship. It will launch a saga of what I would like to call, in fact the bill calls it, the notifications call it the phase of legal migration and then to citizenship. So illegal migrant, legal migrant, and the process to become citizen. Now the second point is that while discussing the CAB 2016, the bill and notification cannot be discussed separately. Both are inextricably mixed up. In the bill, there are three areas in which the Citizenship Act 1955 is being proposed to be amended. I repeat, there are three areas of Citizenship Amendment Act of 1955 that has been attempted to be amended. The first one is I do not want to go into the technical terminologies, amendment of the Clause B of Section 2 of Citizenship Act of 1955. That is the first amendment. What is that clause about? That clause is about defining illegal migrant. Who is an illegal migrant in India? Now, here the bill proposes an amendment. What is that amendment? The bill says, and I quote, provided that the persons belonging to minority communities, namely Hindus, Sikhs, Buddhists, Jain, Parsis and Christians from Afghanistan, Bangladesh, Pakistan, who have been exempted by the central government by Passport India Act 1920 or from the application of Foreigners Act 1946 or any other made thereunder shall not be treated as illegal migrants. So that is the first modification that this proposed bill tries to make. That means it tries to make these six communities under certain conditions as applied by Passport Indian Act and by the Foreigners Act 1946, the amendment that has been made, that will enable them to remove from this clause called illegal migrant. It might lead to legal migrant and then to citizenship. The second amendment is the cancellation of registration of overseas citizen under certain conditions. Well, that is not much of application, so I do not want to detail out that clause. The third one is another important one, is the clause D of the third schedule of Citizenship Amendment Act 1955, by which for the above mentioned communities, the communities that we have talked about, their period of residence has been reduced from 11 years to 6 years. That is the third amendment that this bill proposes to make to the Citizenship Citizenship Act of 1955. So these are the three amendments that this bill proposes to make. My third point is that there is this, relation between bill and notification. What is that relationship? The bill, however, doesn't present a complete picture when it comes to the legislative intent of the government due to two notifications. These two notifications, which were issued on 7 September 2015. They amend rules under the Passport Order of 1950 and Foreigners Order of 1948, as I have said. In these two notifications, we have two things. The first one is these two notifications talk about religious persecution, that is number one. Number two, it talks about the cutoff date of 31st December 2014. So these two notifications on passport order and the Foreigners Order 1948 makes here two things. One is those people who are religious persecution, who are facing religious persecution, would get this benefit, number one. Number two, it says the cutoff date would be 31st December 2014. These two areas actually have been left out by CAB 2016. These two aspects have been left out by the Citizenship Amendment Bill 2016. And here, there is a prospective dimension of open-ended granting of citizenship or removal of the illegal migrant tag. So there you have the prospective dimension. My fourth point is that though the bill government intention is there to remove the illegal migrant tag to those 6 communities, but the methodology to provide that legal migrant tag is extremely difficult. I repeat, the government intention is to give them remove the illegal migrant, and hence they will become legal migrant, and hence they will apply for citizenship. These 3 aspects. However, the intention is there, but the methodology which has been detailed out is extremely difficult. How? Let me tell you. They must apply for citizenship later on. Now, what is the methodology to get waiver from being declared as illegal migrant? What is that methodology? That methodology, as Ministry of Home Affairs says, and I quote, perhaps covered by the notifications, persons covered by the notifications dated 7/9/2015 issued by Ministry of Home Affairs will be required to submit an online application for form of LTV. LTV means long-term visa. Is it a long-term visa? So that means anyone who wants to get the benefit of this notification will have to apply for online application for LTV. LTV means long-term visa. Now, in order to attain that long-term visa, Government of India has detailed out SOPs, Standard Operating Procedures. Now, that was issued on 8/01/2016, 8 January. Now, what are the main tenets of those SOPs? Number one, application are to be submitted online and LTV will be granted after detailed enquiry by Foreigners Regional Registration Officer, the security agencies like IB and SB, and the recommendation by respective state governments. That is in case of those who have legal documents like something of passport, something of when they came out, something of the religious persecution, something of property in Pakistan, Bangladesh or whatever. That is in case of those who are with documents, which is applicable in case of Western India. Because in Western India there are around, as per the JPC report, there are around 31,000 applicants from Western India having those documents. That is the Western perspective. But in Eastern perspective, that is in Northeast India, in case of applicant without having documents or incomplete documents, that is in case of Assam or in case of Northeast, what will happen to them? Those who are not having documents or incomplete documents will be referred to Foreigners Tribunal, and for those who have no documents such as Pakistan, Bangladesh passport, that they are minority, that they do not have any bank accounts or land documents or proof of religious persecution. Now these people, these cases will be referred to Foreigners Tribunal. So the grant of LTV, that is the long-term visa, is dependent on number one, field investigation by various agencies, that is by FRRO, that is Foreigners Regional Registration Officer. Second, opinion of Foreigners Tribunal. Third, recommendation of state governments. And fourth is security vetting by SB, IB, etc. So in this second case, the second case is really problematic. And the Congress opposition to the Citizenship Amendment Bill is grounded on this line, that effectively you are not giving any effective methodology to attain citizen, particularly by the linguistic minority. If you read the JPC report, and particularly the response by our MP from Barak, what's her name? Susmita. Susmita has given a very detailed account, and her opposition on this ground, that on the one hand you are talking about giving them the removing this illegal migrant, but on the other hand, the methodology that you have through this standard operating procedures, it's a very difficult. But nevertheless, because particularly in case of Foreigners Tribunal, this is a sub-legal institution, interference in that particular Foreigners Tribunal could be very difficult, because right now many cases are there which are pending in front of Foreigners Tribunal. So her point is this, that whether these people will become stateless. And my next point, more.
You take your time.
5-6 minutes. My fifth point is that to keep the secular context of the Constitution, rather than specifying those 6 specific communities, I would argue that we could have used terminologies like persecuted communities or persecuted minority communities. That would have been a more acceptable ways of looking at. Particularly symbols are important. Why when we talk about the constitutional norms and characteristics, perhaps we could have gone for this kind of terminology, and these are already used by our previous Act of 1950. I will come to that. My sixth point is that the case of Assam is different, and Assam could have been left out from this process. How? Because we have another act called Illegal Immigration Expulsion Act of 1950. Now this Illegal Immigration Expulsion Act of 1950 has been validated by the IMDT judgment of 2005, the Sarbananda Sonowal case. Now what is this act about? Illegal Immigration Expulsion Act. And also the Permit Act. There was another ordinance issued by then Gopinath Bordole government in 1948. I am working on that. What is this Illegal Immigration Expulsion Act 1950? It says that those people who are coming out of then is Pakistan and who are detrimental to the interest of India / tribal people of Assam, they would be summarily deported from Assam and India. Then next paragraph says, however, the above clause would not be applicable to those who have come to Assam due to persecution, due to displacement, or due to fear of life that they might be persecuted in East Pakistan. So Illegal Immigration Expulsion Act, we thought its validity was over. But if you look at the judgment pronounced by the Supreme Court in 2005 in Sarbananda Sonowal case, and this IMDT which made Passport Act, Foreigners Act, and Illegal Immigration Expulsion Act null and void, but the judgment said that from today, these 3 acts are applicable in Assam. What are those? Passport Act, Foreigners Act, and the Illegal Immigration Expulsion Act. That was the last fade-in of the Supreme Court judgment of 2005. So if there is a real situation in Assam, I believe this was a sufficient ground to look at which some modifications could have been there. So I believe, and even Gopinath Bordole in 1948, he also, the government, Congress government at that point of time also brought a permit ordinance. I have a copy of that ordinance, and it details out the problems that Assam has been facing. And similar, actually that Illegal Immigration Expulsion Act was drafted by Congress government from Assam. My last point is that, now the problem comes with NRC. Now NRC, particularly about NRC. The estimate is that about 7-8 lakh Bengali Hindus will be, or maybe 10 lakhs Hindus would become, would be declared as illegal migrant or foreigner, whatever. Now, through the application to this NRC, they have applied to be Indian citizens and they claim that they are Indian citizens. Okay, they have claimed that and they have supported, must have given documents in favor of that, yes, we are Indian citizens. But now if they want to avail the opportunities of CAP 2016, they'll have to contradict themselves. They'll have to contradict themselves and they'll have to say, no, we are not Indians, we are Bangladeshis. So what is the provision of NRC? If someone tries to fabricate documents, they will be sent to jails. So there are certain operational, issues, because now once they are declared as foreigner, they will claim that no, we are sorry, we have given false statement. We are not Indians, actually we are Bangladeshis. And we are Bangladeshi Hindus, so we are persecuted, now we treat us differently. So they have to contradict themselves. So according to NRC, if you look at the website, it is said that if you provide any fraudulent documents, you will be summarily sent to jail and you will be punished. So what will happen to them? So they will have to contradict themselves. Once you say that I am a persecuted person, well, that is also very difficult to substantiate. Even anti-national person might say that I am persecuted Hindu. So that methodology, number one, is very difficult. Number two, to fix someone as persecuted, I believe, will require lot of verification, lot of antecedental kind of verification, so on and so forth. So my point is that what is happening today in Assam is the Batil Karan. Batil is impossible. What I suggest, I prescribe that there should be sufficient amendments. Amendments to this, particularly the case of Assam should be amended. And Batil is impossible because this is not the first time that Citizenship Amendment Bill has come into being. In fact, it could be 5th or 6th time. In fact, the most important one that was so much detrimental for Assam was 1986 Amendment, which said that anyone born in Assam or India will be Indian citizens by birth, irrespective of the nationality. That is the most harmful for Assam. Then second, another modification was, I think in 93, whereby it was said that anyone by birth shall be citizen of India or Assam, provided one of the parents is Indian. That is the second modification. And the third modification again brought out by BJP in 2004, which said that anyone born in India shall be Indian citizen, provided none of the parents are illegal migrants. So this is not for the first time that the Citizenship Amendment Bill has been amended. So therefore I prescribe that, rather than taking out this bill lock, stock and barrel, we should need to now come up with logical points so that these amendments could be brought and it should make more logical, more in tune with the constitutional propriety of this country. Thank you so much.
Next, I would like to invite Professor Samir Kumar Das to